everybody. I, Siddhi Rathod, will be presenting on the topic right to privacy. So, what does privacy mean according to you all? You can just put it in the chat box. Yeah, right. Correct. So, what does just a minute, sir? Okay, what is privacy? What does the word privacy means? The right to be let alone, the right of a person to be free from any unwarranted publicity, the right to live without any unwarranted interference by the public in matters with which the public is not necessarily concerned. In simple terms, I can say that the state of being free from public attention. The next comes is constitutional context regarding right to privacy. Article 21 of the Constitution states that no person shall be deprived of his life or personal liberty except according to procedure established by law. Every human being has certain confidential or superstitious part which they don't want to indulge in public domain. Now, stressing to the word privacy, it is a very dynamic concept which was needed to be elucidated or make it clear. Right to privacy is such a right that came up into existence after widening up dimensions of Article 21. Earlier, the Constitution does not grant any right to privacy. This came up into consideration after the case that is Kharak Singh versus State of Uttar Pradesh. Now, this case relates to surveillance, where due to dacoity charges on Kharak Singh, he was arrested, but due to no substantial evidence against him, he was given bail. Now, UP police to collect some evidence against Kharak Singh through UP police regulation use, they put surveillance charges on Kharak Singh. Now, what this UP police regulation use says is that they can consider anyone as suspect. There will be domiciliary visits. If the police calls them 2 a.m. at the night, they have to visit the police station. Third is that there will be tracking on each and every aspect of the income and expense account. Now, after seeing all this, Kharak Singh filed a writ petition against the surveillance and the UP police regulation use which was going on him. Kharak Singh said that it is violating his right to movement, right to life and liberty, and right to privacy as well. Now, Supreme Court gave a judgment saying that only domiciliary visits were deemed unconstitutional, but every regulation were deemed valid. The Supreme Court also said that right to privacy is not guaranteed under Constitution till now. So Justice Subba Rao, who was one of the judge in this, said that Article 19(1)(d), freedom of movement, maybe that is secretly doing business or meeting friends. Now, this movement, if anybody is tracking, how can it be a free movement? The Supreme Court gave a verdict that in this, that right to privacy is not guaranteed under Constitution. The next case is that Justice K.S. Puttaswamy versus Union of India, the most lengthiest and the longest running case, which is famously known as Aadhaar case. Now, what this case says that, so Aadhaar is a national identity project for which a new agency was formed, that is UIDAI. Now, in Aadhaar, Indian residencies, that is biometric data, facial expressions, retina, everything is collected and given a 12-digit unique identification code to everybody. The objective behind this was to bring efficiency in public delivery schemes and to curb corruption. So the government collects everything and uses for different purposes. But later what happens is that the government gives Aadhaar a lot of welfare schemes, that is public distribution system, midday meals, etc. For all this, Aadhaar was made mandatory and compulsory. When people got to know about this, they started opposing and said that it is violating the right to privacy. The collection of personal data and everything is violating the right to privacy. So former Judge K.S. Puttaswamy related Aadhaar with welfare scheme and said that it is violating our right to privacy. Government can't remove public welfare schemes because it is a fundamental right of the citizen to enjoy the public welfare schemes. So later, Advocate General of India also said that Indian citizen does not have any right to privacy as a fundamental right. Now, supporting to this argument, They supported the case that is Kharak Singh versus State of Uttar Pradesh, where they mentioned that right to privacy is not guaranteed under Constitution. This was a 6 judges bench. Now, seeing all this in the case of Justice K.S. Puttaswamy versus Union of India, they decided to make a unanimous decision regarding it and said that uh, Indian citizens do have right to privacy. There is no need to give a separate article to protect right to privacy as it is included in Article 21. It is the fundamental right of each and every citizen. So it is guaranteed under Constitution. The next comes is Personal Data Protection Bill 2019. Seeing various issues regarding Aadhaar and everything, the government decided to introduce the Personal Data Protection Bill 2019. The Union Cabinet Minister on December 4th approved the introduction of Personal Data Protection Bill in India. The draft of this bill was being done by B.N. Sri Krishna, who was a former judge who was a high level expert and drafted this bill in 2018. But the introduction of bill was given in 2018. Now, what this bill says is that it is divided into two parts. One is personal data and one is non-personal data. In personal data, the name, address, everything is collected, and this data can be processed in India as well as outside India. There is no restrictions for it. Second comes is sensitive personal data, that is maybe gender, health data, financial, caste, etc. All this information can be processed in India. But if you want to process outside India, you have to take the permission of Data Protection Authority. With the approval of Data Protection Authority, you can process outside India. The third is critical personal data, where military-related information, national security information is collected, and this is strictly being said that it should be processed in India itself. It shouldn't be processed outside India. The second part is non-personal data. That is first one is social media verification. The bill requires social media companies which are deemed significant data fiduciaries. That is, the data fiduciaries are something which collects or processes data based on factors such as volume and sensitivity of data to develop their own verification mechanism. Second is Data Protection Authority. Creation of any independent regulator, Data Protection Authority, which will oversee assessment and definition making. In simple terms, Data Protection Authority will be having a data protection officer who will be taking care of all this. Third is purpose limitation and collection limitation. The bill proposes purpose limitation and collection limitation, which limit the collection of data to what is needed to be clear, specific, and lawful purposes. Fourth is access to individuals and portability. It also grants individuals the right to data portability and ability and transfer one's own data. It also grants individuals the right to data portability and the ability to transfer one's own data. Now, if the company who is storing data, if they doesn't follow all these rules and they are violating, there are penalties for this. For minor damage, there is for 5 crore rupees or 2% of the turnover, and for major damage, it is 15 crore rupees and 4% of the turnover. Later, what happened is that Justice Sri Krishna said that the bill cleared by the cabinet is different from the original draft bill. The bill which is passed in its current form, it should be challenged in the Supreme Court. It has been referred to a joint committee which is expected to table its report during the budget session. But after 2019, there were 3 budget sessions where it was not mentioned about this anything. This has still remained a bill but not turned to an act. Next is some aspects regarding right to privacy. First one is phone tapping and right to privacy. Now, what is phone tapping? Phone tapping is the activity of listening secretly to someone's phone conversation using special electronic equipment. I would like to take a case, that is People's Union for Civil Liberties versus Union of India, in which, now in this case, what happened is that former Prime Minister Chandrasekhar blamed the government that they are tapping his and 27 more politicians' phone. So after listening this, there was a CBI investigation started where they enclosed the widespread phone tapping issues which were run by government. So PUCL, that is People Union for Civil Liberties, filed a writ petition saying that the Supreme Court should give clarity about phone tapping or wire tapping issues. They also challenged the Indian Telegraph Act Section 5 subclause 2, saying that it gives government powers while it gives powers to the government to tap phone during safety or emergency purposes only. Now, the verdict came into existence that telephone conversation are confidential and intimate in nature. This comes under right to privacy. There is no need to give a separate article. This comes under right to privacy and it is under Article 21. The second one is health and privacy. Health sector is an important matter of concern in privacy and also one of the major aspects of right to privacy. Health information not only includes information about the health or disability, but also the information related to health one may receive. It's human tendency that the information regarding health is considered highly sensitive by many people. Now, a doctor is under oath or medical ethics for not disclosing any secret information about the patient because it adversely affects the life of other people. I would like to take a case that is Mr. X versus Hospital Z. The name of the case itself arouses curiosity to why the name of the partners are not disclosed. Let's see what happens in this case. A man, that is Mr. X, was supposed to marry his fiancée, but he was called off because he was diagnosed as HIV positive. Let's see the background of the case. So in this case, Mr. X was a medical graduate and he was appointed as a doctor in Nagaland Medical Services. The appellant X was going to donate blood to someone, so he went to a he went for a blood test in Hospital Z, where he was tested HIV positive. Several persons, including in his family and those belonging to his community, came to know about his HIV positive status. The hospital disclosed his health information to his relatives. So Mr. X approached the National Commission against the respondent hospital, claiming for damages for disclosing the information about the health condition. The damage was a social damage. As the hospital has some ethics, so according to it, the hospital has the responsibility to keep his reports confidential. The National Commission summarily dismissed his complaint on the ground that the appellant could seek his remedy in a civil court if he desired. So Mr. X then moved to Supreme Court and said that it should be that the Mr. Z Hospital Z should be liable for the compensation for what he disclosed the matters about his HIV status. As they violated by disclosing its identity, he suffered a great mental agony. The court observed that even in the code of medical ethics carried out an expectation to the rule of confidentiality and permitted to disclosure in certain circumstances with public interest. But the main thing is that at least his relatives should know about his conditions so that they can take precautions. But here, right to privacy has infringed this by disclosing his information. So, Hospital Z is liable by infringing, and he has to pay compensation to Mr. X. Right to privacy is one of the humanitarian right. Right to privacy is important, like the right to life as well. So, as a wife, should know that he has HIV positive, as she also has right to life. As the information disclosed, so she broke the marriage which was going to be held. So here it violates the right to privacy as well. The next comes is punishment regarding the punishment and violation of right to privacy. The first one is Section 43A, compensation for failure to protect data. This says is that where a corporate body possessing and sensitive data in a computer resource which it owns causes wrongful loss to any person is liable to pay damages to a person so affected. The second comes is Section 66C, punishment for identity theft. That is, whoever dishonestly make use of electronic signature, password, or any identification feature of a person, he shall be punishable with imprisonment for a term of 3 years and shall also be liable to fine and 1 lakh rupees up to or more. Third one is section 66E, which is most important one, punishment for violation and privacy. Whoever intentionally or knowingly captures, publishes, or transmits the image of a private area of a person without his or her consent, under circumstances violating the privacy of that person, shall be punished with imprisonment, which may extend up to 3 years, or with fine not exceeding up to 2 lakh rupees, or with both. Then comes this breach of Privacy Act recent cases, bully by controversy. Does anybody know about bully by case? You can put it in the chat box. Yeah, correct. It's auctioning of women. Yeah, correct. So what is this bully by controversy? The recent case, as you have seen in Twitter or something, actually during New Year, weekend social media platform was flooding with photos of several women, especially Muslim women, with captions like bully buy of the day, hashtag bully buy of the day, or Suli deals, bully deals. These were the hashtags were made. Now this case has literally shocked the entire country, where a woman is being auctioned, where pictures of women are being posted online publicly in a very degraded manner, which is violating the Women's Indecent Representation Act 1986 and also violating right to privacy. Now, you might be thinking that this might have been done by a hardcore criminal or anybody, but no, it is done by a 18-year girl student who is from Uttarakhand, and a 21-year engineer boy who is also from Uttarakhand. And now this seem to be making hatred between this was done because to bring hatred between Hindus and Muslims. This was mainly done to bring hatred among the religious community. So here also the recent case, it also says that it violates right to privacy and also Women's Indecent Representation Act 1986. The second is viral pictures of Virat Anushka's kid. Recently, though the Virat Anushka requested the public not to forward or not to take pictures of their child or forward it, but recently you have observed that her kids' picture were getting viral and forwarded. This also was violating the right to privacy as well. The second is WhatsApp controversy regarding its new privacy policy. What this says is that last year around Feb, you might have seen there was a news regarding WhatsApp controversy regarding its new privacy policy. So the old WhatsApp policy, what it says that it wasn't safe, but certain, because WhatsApp was storing profile picture, the number, the name, everything was being collected in the WhatsApp store. So the government came up with the new IT rules saying that they have to cut down this end-to-end encryption policy, which is there in WhatsApp. But WhatsApp said that they won't delete this policy because it violates right to privacy. So, because due to certain circumstances, what WhatsApp has taken this case to government of India, this case to Delhi High Court, saying that India's new IT rules violate right to privacy of Indian users and called for social media intermediary rules to be declared unconstitutional. Reuters Reuters has consistently opposed calls to end-to-end encryption of this platform because it was violating their right to privacy. So WhatsApp denied all the IT rules of this and said that they won't delete this policy because it violates right to privacy. So I would like to conclude it by saying that WhatsApp is a primal national right which is inherent to an individual. The interplay of technological advances and the right to privacy in this digital age needs to be closely scrutinized. Irrespective of any technological changes, the respect of right of individuals to make a choice of how and where they want to live and pursue their individual dreams, but be protected. For more decades to come, the most important right, the right to be left alone. Thank you.